Welcome back dito sa Criminal Law Review playlist. Kasi last week puro tayo civrev eh. So ngayon balik tayo sa crimrev. Pero ito na yata yung magiging last topic natin. Actually, pwede siyang kasya sa isang video. Kaso parang magtatagal siya siguro ng isang oras or something. And na-realize ko, nakakapagod yun. Kapag sobra ng isang oras yung video, nakakapagod din dumaldal, kailangan ko rin ng break. So, siguro this video and 2 more para matapos yung Criminal Law 1. And after matapos yung Criminal Law 1, magpo-poly na tayo. Tapos after ng poly, magpa-property tayo. Tapusin natin yung property. Then, baka November na ulit ako mag-crimrev, which is yung book 2 ng RPC. So, yon. Ito na muna yung last upload for Criminal Law Review. Tapos, tututukan ko naman na yung Political Law Review and yung Civil Law Review. Alright, G na G. So, persons criminally liable. When more than one person participated in the commission of the felony, the law looks into their participation. The revised penal code classifies them as the principal, the accomplice, and the accessory. So, na-mention na pag-usapan na natin to sa previous videos, pero ito, kasi diba, napag-usapan na natin yung criminal liability before. Pero balikan lang natin, tapos mas grabing discussion lang. Okay. So, the classification is true only under the revised penal code and not under special laws because the penalties under the latter are never graduated. If the crime is punishable under the special penal laws, the more appropriate term for persons criminally liable are quote-unquote offender, or culprit, or accused. In grave and less grave felonies, all participants are criminally liable. In light felonies, only principal and accomplice are liable. So, offender. It is the active subject or party of the crime. As a general rule, only natural persons can be the active subjects of a crime due to the highly personal nature of criminal responsibility. Juridical persons cannot be active subjects. Only natural persons can act with personal malice or negligence. Moreover, penalties such as substitution of deprivation of liberty, like subsidiary imprisonment, for pecuniary penalties in case of insolvency, or destierro, can only be executed against individuals. So, alam naman natin kung anong natural person sa juridical person, na discuss na natin sa civil law yan, right? Natural person, yung tao. Juridical person could be the state, its subdivisions, corporations, yung mga entities that have the capacity to act or have juridical capacity, meaning to act with legal effect, pero hindi sila tao. And of course, hindi sila pwedeng maging criminally liable kasi di man tao yan eh. Paano mo ikukulong yan? Ano lang yan eh, parang fiction, parang legal fiction. Di naman siya totoong creature eh. Pero, siya, separate entity siya, composed of persons. May mga instances wherein yung persons composing the corporation nagiging criminally liable. So, mas okay yan pag-usapan sa corporation law. Special laws, ito yung exception. Special laws wherein corporations are expressly penalized for their violations. Pero pag nape-penalize yung corps, civil liability lang eh, 'di ba? Unless na yung persons, yung mga directors niya, yung mga persons responsible na nandyan sa corporation, criminally liable. So, nakasulat naman yan sa, for example, Revised Corporation Code, kung ano yung, dyan, kung ano yung mga punishable acts dyan na pwedeng maging criminally liable ang mga persons composing the corporation. Or Public Service Law, Securities Law, and Election Code. If the offender is a corporation, the following are held liable if they are responsible for the violation or are indispensable to the commission of the offense. Director, trustee, stockholder, member, officer, employee, as the case may be. So, offended party or the victim. Ang dami kang typo, simula pa lang The passive subject or the party who suffered loss, injury, or damages due to the criminal act of the offender. So, remember, sino nagfa-file ng criminal case? Napaka-basic nito. It's the state through the prosecution. Through the prosecutor. Not the victim. Anong treatment sa victim or offended party? Para lang siyang witness. Because when someone commits a crime, yung crime kinocommit against the public. Kaya yan people versus ganito. People versus ganyan. Ganyan versus people. Diba? Anyway, tip lang. Pag yung Supreme Court decision, people versus saldo, kunwari, ibig sabihin yan, no? Ibig sabihin, nung sa Court of Appeals or Regional Trial Court, kunwari kung nagdumiretso sa Supreme Court, ibig sabihin, talo si accused sa last na kaso. It's because kapag ka na acquit na, 'di ba? Kapag ka, for example, inacquit ng lower court, acquit na talaga 'yan. Hindi pwedeng i-appeal pa unless merong God allege or grave abuse of discretion amounting to lack or excess of jurisdiction. So, yan yung sa criminal cases. Bawal kasing i-appeal pa pag na-acquit na mado-double jeopardy yung accused. So, yun lang. Naalala ko lang na i-share. By the time that you reach 4th year, alam nyo na din naman yan yung mga ganyang bagay. Principal by direct participation. An active participant in the commission of the offense and one who participated in the criminal resolution to commit the offense. Also included as principal by direct participation are those who cooperate in the commission of the crime by performing overt acts which by themselves are acts of execution. So, si offender, nag-participate sa criminal resolution. Okay? Tapos, nag-participate siya na, sige, magko-commit tayo ng crime. And then, after niya maging decided na magko-commit siya ng crime together with others, the offender carried out their plan and personally took part in its execution by acts which directly tended to the same end. So, merong criminal resolution, okay, na, okay, gagawin natin yan. Sige, agreed. Tapos, sa execution time, andun din siya. Nag-participate siya doon mismo, pumunta siya doon mismo, or may ginawa din siya mismo na direct na acts of execution. Pinag-usapan na natin last time yung stages of execution, di ba? So, yun yung principal by direct participation. Hindi kailangang, pwede kang maging principal by direct participation na ganon, kahit walang conspiracy, basta you are liable as a principal by direct participation if ikaw mismo yung gumawa ng crime. Ganon. Principal by direct participation in a conspiracy. In order to convict the accused conspirator as a principal by direct participation sa case ng conspiracy, it is necessary that conspiracy among him and his co-accused be proved. Conspiracy, like any other ingredient of the offense, must be proved as sufficient as the crime itself through clear and convincing evidence, not only by mere conjectures. Proof beyond reasonable doubt, however, is required to establish the presence of criminal conspiracy. Yung criminal conspiracy, ito yung conspiracy is in itself a crime. So, yung conspiracy kasi, napag-usapan na rin natin, diba? It's, pwede siyang method or mode of committing a crime. Na marami kayo, nag-conspire kayo. Manner, yun pala yung mas proper na term. Manner. Pero yung conspiracy itself, kunwari nag-conspire kayo na patayin ang isang tao, pag hindi nyo naman talaga pinatay, wala kayong criminal liability. However, may mga crimes na yung mere conspiracy ninyo, punishable na agad, liable na kayo agad. Like conspiracy to commit treason, for example. So, kapag ganon, proof beyond reasonable doubt. Kapag ka manner yung conspiracy na tinatry i-prove, then clear and convincing evidence. So, you could just look sa previous videos ko na meron doon na pag-usapan na yung conspiracy, like in depth. Conspiracy is negated by the acquittal of the co-defendant. One cannot be held guilty of having instigated the commission of the crime without first being shown that the crime has been actually committed by the other, except when the principal actor is acquitted because he acted without malice or criminal intent. So, principal by direct participation, sa case ng conspiracy, kailangan mo ring i-prove yung conspiracy. Principal by inducement, those who directly force or induce others to commit a criminal act. So, inducement be made with the intention of procuring the commission of the crime. And that said inducement is the determining cause of the commission of the crime by the material executor. So, kung in-induce mo naman yung isang tao mag-commit ng crime, for example, murder. Pero, hindi naman murder yung ginawa niya, robbery. Okay? And, for example, in-induce mo siya, pero meron siyang iba yung nag-lead sa kanya to commit such crime. Or iba yung nag-push sa kanya, not necessarily your inducement. In-induce mo siya pero wala namang effect sa kanya. So, kailangan yung inducement na yun yung nag-push sa tao na mag-commit ng crime para maging liable yung nag-induce as principal by inducement. So, inducement by using irresistible force or causing uncontrollable fear. It can be exempting if such physical force would produce an effect upon the individual that, despite all his resistance, it reduces him to a mere instrument. If fear is the reason, such fear must be grave, actual, serious, and such kind that majority of men would succumb to such moral compulsion. Mere threat of future injury is not sufficient. Compulsion must be such that it reduced the offender to a mere instrument. Wala na siyang magagawa or else papatayin siya. Mga ganong scenario. Not only without will but against his will as well. It must be of such character to leave the accused no opportunity for escape. Na no choice siya. Pero the way that you would appreciate it, yung irresistibility and yung uncontrollable fear, which is napag-usapan na natin previously nung diniscuss natin yung mga circumstances, no? Ano siya, sa perspective siya ng tao, yung receiver ng force, yung tinatakot, yung pinapwersa. Kasi hindi pwedeng i-argue na, well, pwede naman niyang takasan yun at the time or pwede namang di niya gawin, parang ganon. Kailangan i-take into consideration yung circumstances wherein kung ikaw ba nandun sa posisyon niya, would you act the same way? A reasonable person would. Inducement by giving of price or offering a reward or promise. The one giving the price or offering the reward or promise is a principal by inducement, while the one committing the crime in consideration thereof is a principal by direct participation. And here, there is collective criminal responsibility. Okay. Para sila hindi parang, nag-conspire sila sa each other. So, kapag si A binayaran yung isang tao na patayin si B, then, kapag namatay nga si B, diba, binigyan ng pera, pinapatay, it's as if yung nagbigay ng pera, yun yung mastermind, parang siya na rin yung pumatay. So, equally guilty sila of murder in that case. Inducement by using words of command. The person who used the words of command is a principal by inducement, while the person who committed the crime because of the words of command is, again, a principal by direct participation. The one who made the command must have intention of procuring the commission of the crime, ascendancy, or influence over the person who acted, and the words used must be so direct, efficacious, and powerful to amount to physical or moral coercion, uttered prior to the commission of the crime, and the material executor has no personal reason to commit the crime. So, next naman, na uri ng principal. So, meron din tayong principal by direct participation, meron tayong principal by inducement. Ngayon naman, principal by indispensable cooperation. So, those who cooperate or help or aid, presupposing knowledge of the ultimate criminal purpose and the commission of the offense by another, without which it would not have been accomplished. So, ano ba yung ibig sabihin ng indispensable? Cannot be dispensed with. Meaning, the crime would not take place were it not for the cooperation of this person. Indispensable cooperation. So, the participation in criminal resolution such that there is anterior conspiracy or unity of criminal purpose. So again, dapat may conspiracy dito na proven. And intention before the commission of the crime and cooperation in the commission of the offense by performing another act. Hindi kailangan yung direct act. So, hindi direct participation. Another act. Hindi siya necessarily acts of execution ng crime, but it is indispensable, and without which it would not have been accomplished. So, for example, kapag yung lugar is, for example, matao, tapos merong lookout, okay? Yung pagiging lookout, sometimes, in certain circumstances or situations, indispensable siya. Kung wala yung lookout na yon, hindi nila pwedeng patayin yung gusto nilang patayin. For example, kapag murder. So, naging principal by indispensable cooperation yung lookout. Pero kung yung pagiging lookout naman ay hindi kailangan, for example, abandoned naman yung place, di ba? Or attended by circumstances wherein hindi kailangan, case-to-case basis kasi ito tinitignan. So, kahit na, for example, sa pagpatay, ano ba yung acts of execution natin? Siyempre, mag-inflict ka ng mortal wound attended by qualified circumstances that qualify the killing from homicide to murder. So, yun yung acts of execution. Yung pagiging lookout, hindi naman yun acts of execution in the commission of the crime of murder. Pero in certain instances, indispensable siya for the commission of the crime intended. Okay, let's go to accomplice naman. An accomplice cooperates in the execution of the offense by previous or simultaneous acts, provided he has no direct participation in its execution, or does not force or induce others to commit it, or his cooperation is not indispensable, meaning can be dispensed with. Sure, nag-facilitate, pero pwedeng i-commit yung crime with or without his or her presence. So the liability of an accomplice is less than that of principals, and they shall be meted with a penalty next lower in degree or by 1 degree lower than that prescribed by law. It is also possible for an accomplice to be liable as such for a different crime than what the principal committed. Okay. So, dapat si accomplice though, alam niya yung criminal design. May community of design pa rin siya dun sa principals. There's knowledge and there's concurrence with the criminal design on the part of the accomplice. Tapos, cooperation in the execution of the offense on the part of the accomplice. By previous, so pwedeng ginawa na niya, pin-repair niya, yung mga dapat gawin para madalian yung mga offender na principal by direct participation, yung magko-commit talaga ng acts of execution. So, previous acts yun. Pwede rin simultaneous. Habang ginagawa nila yon yung crime na pinaplanong gawin, si accomplice may ginagawa din. Pero hindi siya indispensable. Meaning, pwedeng wag niya naman gawin eh. Magagawa pa rin nila eh. Kaso, okay na ginagawa niya para sure. Parang ganon. And there is a relationship between the acts of the principal and those attributed to the accomplice. One can be an accomplice even if he did not know of the actual crime intended by the principal. Basta, 'di ba, sabi ko kanina, kailangan may knowledge and concurrence sa criminal design. Basta alam niyang illicit lang yung act. Hindi niya kailangang malaman talaga yung exact na plano or yung exact crime na gagawin. Basta alam niyang may bawal na gagawin and nag-G siya doon. So, accomplice siya. Accomplices do not decide whether the crime should be committed. Nag-agree lang sila. They only assent to the plan of the principals by direct participation and cooperate in its accomplishment. A person who knowingly consents or agrees, okay, to be married to another, whether man or woman, already bound in lawful wedlock, is guilty as an accomplice in the crime of bigamy. Yung principal by direct participation mo sa bigamy is yung taong kasal na tapos nagpakasal pa ulit, nag-contract ng subsequent marriage. Pero yung taong pinakasalan ng offender, so yung offender na yun, yung principal by direct participation. Yung taong pinakasalan niya, kapag alam naman ng taong pinakasalan na may asawa na pala, alam niya rin na bigamous na yung next na marriage, kahit single siya. Diba? Kahit single siya, tapos yung papakasalan niya, alam niyang may asawa, may liability pa rin siya as an accomplice. An accomplice is exempted from criminal liability when the crime is a light felony and the principal is a relative under the exemptions in Article 20 of the Revised Penal Code, except if said accessory has profited or assisted the principal in profiting from the crime. Okay, so let's go na sa accessory. So ito na yung last, yung accessory. So, a participant in a crime that is neither a principal nor an accomplice, whose liability is subordinate to the principal and accomplice. So, principal, tapos accomplice, 1 degree lower, mas mababa pa si accessory. Because yung participation ni accessory is subsequent to the commission of the crime. Si accomplice, di ba, previous or subsequent acts. Ito naman, after the crime is already committed. The penalty to be imposed for accessories is 2 degrees lower than that prescribed for the felony. So, si principal, yun yung makakatanggap ng full na liability. Tapos, 2 levels daw, pababa dyan. So, meaning, 1 level lower sa accomplice, which is 2 levels lower sa principal. A person may be liable as an accessory if he commits the following acts. First, profiting themselves or assisting the offender to profit by the effects of the crime. Okay, so this is to profit oneself of, for example, receiving stolen property knowing na it's stolen, alam mo namang nakaw. This must, however, be with the consent of the principal. Kasi, kapag wala namang consent ng principal, di ba? Di principal na siya sa theft, hindi na siya accessory to the crime. No? Kasi, ninakaw niya rin yung nakaw eh. Anyway, to assist the offender to profit from the effects of the crime is to knowingly receive and sell stolen property. An accessory should not have conspired in the commission of the theft or robbery with the principal. Dapat yung participation niya after na, subsequent na to the commission. Wala siya dun sa planning part kasi iba na yun. To profit from the crime of robbery or theft, wherein the accused knowingly profited or assisted the principal to profit by the effects thereof. Such accused may be prosecuted as a principal for a different crime, which is the violation of the anti-fencing law. Magiging fence siya. The mere possession of the thing brings about the presumption of fencing. So, sa book 2, didiscuss natin yung mga crimes mismo. Pero yung fencing, ito yung mga nagbebenta ka ng mga nakaw, mga ganyan. To profit from the piracy or highway robbery, knowingly acquiring or receiving property taken by pirates or brigands, or in any manner benefiting therefrom, the accused may be liable for the crime of anti-piracy and highway robbery law as an accomplice. So, next punishable act of an accessory is concealing or destroying the body of the crime or yung corpus delicti to prevent its discovery. So, pag-usapan na rin natin yung corpus delicti before. Ano ba yung corpus delicti? Sa body of the crime, pero it's not necessarily the body, like katawan, body of the crime. So, body of the crime, for example, murder, it's the killing. Ganyan. Hindi yung literal sense na body of the crime. So, balikan na lang yung videos ko para mas in-depth na discussion ng corpus delicti. Next punishable act of the accessory is harboring, concealing, or assisting in the escape of the principal of the crime. Harboring, tinatago mo sa bahay mo. Ganon. Any committed by either public officer or private person. So, any person who knowingly or willfully obstructs, impedes, frustrates, or delays the apprehension of suspects and the investigation and prosecution of criminal cases shall be liable as a principal, hindi na accessory, for PD 1829, which is a decree that penalizes obstruction of apprehension and prosecution of criminal offenders. The offender shall be punished by imprisonment of prison correctional in its maximum period and a fine ranging from 1,000 to 6,000 pesos or both. So, notice nyo, meron parang mga options dito. Pag nag-remedial law, di ba? Nakadepende yan sa prosecutor kung anong ikakaso niya eh. Di ba? Sa crimrev yan eh. Na kung ano ang inallege sa information ng prosecutor, if pasok siya kunwari sa 2 or more crimes, pero pinrosecute niya sa certain law, or for a certain crime lang, then limited lang sa ganun yun. So, pwede siyang pumili. May cases, pwede siyang pumili. Kakasuhan ba ni prosecutor ang offender as an accessory to the crime of robbery? Or kakasuhan ba niya as principal sa fencing? Or kakasuhan ba niya as an accessory for harboring, concealing, assisting the escape of the principal of the crime? Or kakasuhan niya as principal for violations of the PD 1829. So, na obstruction of justice. So, depende yan. Effect of acquittal of principal. If the facts alleged are not proven or do not constitute a crime, the legal grounds for convicting the accessory do not exist. The exemption is if the principal was convicted but not held criminally liable. Oh my God, nabulol naman ako. But not held criminally liable for an exempting circumstance which appreciates personally to such principal and not to the accessory. The accessory in this case may still be held criminally liable because such crime was still committed. The determination of the liability of the accessory can then proceed independently of that of the principal. Okay, so tapos na tayo sa persons criminally liable. Mas may in-depth discussion ako tungkol sa conspiracy. And napag-usapan na din natin before tong mga principle, ganyan. So, balikan nyo na lang if parang nakukulangan kayo sa discussion dito. Alright, so yung next video would be on plurality. Yung plurality, ito yung mga compound crime, complex crime, special complex crime, mga ganyan. Medyo na-mention na din naman natin to dati nung nagde-discuss tayo tungkol sa stages of execution and sa other principles of criminal law. Pero ito mas in-depth lang siya. Tapos, after nyan, penalties at saka extinction of criminal liability na. Alright.